Okay, you're on.
Good afternoon, everybody. I'm Ed Fredericks, and today is Sunday, September 29th, and this is the second fireside chat we've had today. And today we'll be for this chat, we'll be talking about the lawsuit that was filed by myself and Janet Eisenhower. We have retained the services of Jim Costino, and he will go over some of the nuances of the lawsuit. I'll state what my rationale was for filing it, and he'll probably answer some of the technical questions that you might have. Suffice it to say, again, this is pending litigation, and we are somewhat constrained by what we should or what we can talk about. So without further ado, Jim, would you like to start off and just say, describe the lawsuit and what the issues are?
Yeah, we filed an 8-count lawsuit 2 or 3 weeks ago. It's been served on the community. They have retained an insurance company attorney appointed to represent them, so it's not going to be a suit that the homeowners are going to be coming out of pocket to defend, which is good for the homeowners. And let me just cover briefly some of the contentions that appear in the lawsuit. And some of these I touched on in the earlier video. But first and foremost, one of the primary concerns that we had was the passage of special assessments in 2021 to permit the acquisition of the golf courses to begin with. It's my position that under the documents, there was never any authority in the community, the association, to enact special assessment to acquire those golf courses. The ability to enact special assessments is limited to common expenses, and common expenses require that those be related to things that the association has a duty under the declaration to operate, maintain, or control. And they clearly had no duty to operate, maintain, or control the golf courses. This was a new duty that they were taking on by acquiring the courses. So by even raising the money, closing on the course, and taking it over, they violated the documents. So one of the things that we're seeking to do is to invalidate that transaction. Second thing that we're seeking to do is to recover, although it's not about money, because the money is nominal, quite frankly, is to recover the expenses that have been paid pursuant to that special assessment. The third thing is to demonstrate that those were actions that were undertaken that created an inconsistent, substantial change in the character of the community. I talked about that in the last video, that for 38 years the community was responsible for maintaining and operating and improving the common areas being a defined term in your documents that means all of the assets in the community that are communally available for use and enjoyment by everyone who is a dues-paying member of this community. And that doesn't apply to the golf course, because in order to be able to use the golf course, you've got to pay either membership fees to become a member, or pay course fees in order to buy around and play around the golf. So you get no benefit from being a homeowner and paying your assessments to the association in terms of use of the golf club. So that was a fundamental and inconsistent change with the way things have been operated. We're seeking to have that entire transaction unwound. The next count deals with the fact that the financial records of the association are not being maintained as required by Florida statutes. There are a number of mandatory requirements under the Florida statutes that apply to the maintenance of financial records. They have to be maintained in accordance with good accounting practice. They have to be granular and specific. They have to be complete. They have to be, the financial statements that are generated have to be generated in accordance with GAAP, and then each year, they need to be timely audited by the outside auditors for the community, and also produced in a timely fashion and circulated to the community, so the community can stay abreast of what's happening financially in the community. So it's our position that based upon all of the evidence we've collected, they failed to honor that particular requirement in the Florida statutes. And the last complaint deals with the failure to timely produce the audits that are also under an obligation, a mandatory obligation, to produce within 120 days at the end of each fiscal year. So those are the accounts in the suit. Essentially, what we're attempting to do is to arrest some of what we perceive to be the lawlessness that characterizes a lot of the decision-making of this particular board, and to get them to actually come in line with what the Florida statutes require. You know, Mr. Roberts is saying that they abide by the Florida statutes, but it's pretty clear that they do not and have not abided by the Florida statutes, and I think that's irrefutable. There's no good faith dispute about that. The facts are the facts. They haven't produced the audits in a timely fashion. They haven't produced the GAAP created financial statements in a timely fashion. They're not used in special assessments for proper purposes as delimited in their documents. So I think that's going to be a fairly easy lawsuit to win. The more challenging aspect of it is going to be able to prove the issue of whether or not we get to unwind the entire transaction as being something that is inconsistent and incompatible with the historic use of the community. But I think we've got a good shot at that. There are no cases directly on point, but there's enough case law out there to provide me with confidence that we've got a meritorious argument there. So we hope to prevail on all of them. I'm confident, extremely confident, we're going to prevail on virtually all of them. And hopefully there will be some changes introduced as a result of that. That's what this lawsuit's about. It's not about enriching anybody. It's not about damaging anybody. It's about raising the consciousness of both the board and the community as to what's going on in the community, and the fact that boards do indeed have an obligation to abide by the law and the Florida statutes that control their behavior. So that's it in a nutshell. Be happy to open it up to questions.
I'd like to make one comment. My motivation is not to hurt anybody or attack anybody or the board, what have you, or damage anybody's reputation. But when I came into this community, I was faced almost immediately by this golf transaction. And my background being finance and the capital markets, I could see that due diligence was not being performed. I could see a lot of shortcuts, and I asked for information, I asked for answers, I was not provided it. In fact, I was prevented from obtaining information. And so all along I've been following the financial statements, and it's my opinion that the board has not adhered to good practices, has not properly represented the community. If anything, they've more or less served special interests. It's my opinion that they have breached their fiduciary duties, and after 3.5 years, I finally said enough. I saw what was happening in the first part of this year, and I finally said enough and said, if we don't stop it now, it's going to get out of control, really out of control. So that was my motivation. And two things I wanted to accomplish, and it took us a while. We actually started last summer of '23, looking for legal representation. And we didn't find Jim, we didn't get to Jim until late spring of 2024. What we wanted to accomplish was twofold. One is, as Jim says, we wanted to adjust behavior so that the boards adhere to their fiduciary duty. They have to represent us all. They can't just say, well, you don't count, we don't, listen to you, we don't listen to you. All of us has to be equally weighed. In terms of, and then the second thing is we wanted our finances, or from what I could see, we needed our finances to be properly accounted for. It is amazing to look at some of the financial statements and see numbers appear and disappear without any rhyme or reason. And I'm not going to get into specifics. I'd be happy to have a private conversation to discuss them, but again, because there's pending litigation, I'm not going to come out with specifics of what we are seeing or have seen or complaining.
We have cited a few representative examples in our complaint, but there are many more that we could have cited that we didn't cite.
So that was my motivation. I'm not doing this to hurt somebody. I'm not doing this to get on the board, obviously, because I don't know if any of you realize this, but there is a bylaw saying that if you're in litigation with the board, you can't run for the board. So, I mean, if that was my ultimate goal, then again, I'm going about it the wrong way. So again, behavior. I want to adjust behavior so that our leadership serves the community. And I want our dollars and cents to be properly accounted for. That's my motivation. And I want to say that I feel we got the right man here with Jim. And it took us a long time to get through all the data, all the numbers, to get Jim comfortable with being able to even come up with an opinion as to do we have a complaint or not, or what would be our complaint. But God bless him, he spent the time, he made the effort, and I'll never forget the second meeting we had, and when I knew we had the right man, because we were going through documents, and Jim was looking at these documents, and he said, brazen. And then he said, what took you so long? And I said, Jim, that's our man. I said, Janet, that's our man. Jim looked at these documents and said, what took you so long? Meaning, why did we wait so long before we hired counsel? So with that, I'll open up the floor. If anybody has any questions, like observations. Jim?
This question is for you, Jim. I'm hearing from our board, and I'm also reading it on our private plantation next door, that this lawsuit is not just suing the board, but it's suing us, the homeowners. Could you clarify if I personally or any of my neighbors are being sued directly?
Yeah, well, you're not being sued directly or indirectly. That's a myth, and I don't know where that rumor got started, but no, we're suing the association as an entity. And as I mentioned earlier, the association has insurance coverage, so the insurance company is paying for the attorney that they've appointed to represent the association in defense of this matter. There have been no allegations raised against individual homeowners, no request for compensation or relief of any type against individual homeowners or even collectively against the homeowners as a whole. So that's a false statement.
And if I could add to that, what is the price of corruption? If someone's saying, oh, this lawsuit's going to cost us, and even if we're insured, our insurance rates are going to go up. Well, what's the price of corruption? How does corruption affect housing prices? If we've had 3, 4 assessments and are going to have 5 or 6 more, If our suddenly monthly assessment jumps $100, what does that do to our housing prices? What does that do to our pockets? What is the cost of corruption? Corruption, from what I know in the capital markets, sells at a discount. And it's the people that adhere to the law, are squeaky clean, have good, strong corporate governance. Those entities sell at a premium. So this lawsuit is going to help this community because it's going to clean up these problems, and people are going to recognize that and say, this is a good, strong community with strong corporate governance. So there's more potential for this to help this community and help housing prices, make it a much more attractive place to live.
We just want people,
Thank you. Thank you.
we just want people to have the information, it's accurate information and complete information, so they can make an informed decision. It's not about any particular objective per se. It's about making sure that the information is accurate, is available and accessible to everyone, and that folks can determine for themselves what the most appropriate next steps would be. But yeah, I mean, otherwise, your options are to just allow it to happen, right? So that is an option. You could ignore it and allow it to happen and just continue to see a board get away with all sorts of things that are contrary to law. But those are your options. You either act to try and put a stop to it for what you believe to be the good of the community long-term, and that will benefit the community long-term. Like Ed said, you clean up your corporate governance, you clean up your financial records, that's going to have a positive impact on the marketability of your homes here in this community, and the values of your homes in this community, because people are interested in that sort of thing. They don't want to see disputes over financial matters in the community. And we're not interested in...
Or seeing hundreds of thousands of dollars going out the window.
We're not interested in protracting this lawsuit any longer than it needs to go. We'd love to get it resolved, but at the same time, we want them to act in accordance with their statutory requirements, and we want them to correct and clean up their acts. Yes, ma'am?
In your opinion, what is the most egregious count that has occurred so far?
Well, in my personal opinion, there are several of them that are pretty egregious, but the most egregious one would be the fact that they've purchased the golf course to begin with when they had no authority to do that. It's pretty clear. They had no authority to purchase the golf course. And they utilized the vehicle of a special assessment to do so, when that's not what the special assessment was there to accomplish. It was not available for the acquisition of a golf course or the acquisition of any additional property. So.
But Jim, one of the counters to what you're saying is we voted for it. How can the acquisition of the golf course how can we not have authority when we did vote for it?
Well, you can vote for something, but if it's still illegal under your documents are going to control. So
Thank
you can't, it's just because you've engaged in certain behavior, if it's improper under your contractual requirements, that's going to control your vote. Number one. Number two, there's a lot of misinformation then, just as there is now, that scared people to death, that rushed them to making decisions, just like the same old story again and again. They wait till the last minute when there's a financial crisis, and all of a sudden people need to act immediately, otherwise, there's going to be Armageddon, and they scare people by claiming that their property values are going to plummet, 15, 30, they even heard one realtor on that program say 50%.
15%, yeah.
I mean, that was astonishing to me. And when we had conferred with the Lake County property appraiser that is knowledgeable concerning the property values in all of Lake County, identified, I think there were 6 or 7 different communities in Lake County that had golf courses at one time, that discontinued those golf courses, and said that in each and every case, there was no suffering of the diminution in value to those properties. Not one case. And this is not me saying it. I mean, I didn't have the ability, I didn't have the first-hand knowledge to be able to be in a position to make such a declaration. But this is the head honcho over at Lake County and residential appraising department. So,
That's an informed opinion.
yeah. Yes?
What happens if you win?
Well, we're hoping that, number one, that the golf course situation gets unwound, that we're no longer tied to the golf course at all. That the community no longer has any entanglement with the golf course. The judge is going to have to establish some equitable parameters to how that gets all unwound, but that's what we're hoping to accomplish. That's the big result that we're hoping.
And if I could take,
Go ahead.
if I could make a comment. From that, hopefully, we can come to the decision then that if you want to support the golf course, you can. And if you don't want to support the golf course, you don't have to. So I think that would be a very, very important conclusion to get to.
Right. And there were some good ideas that were shared at some of the meetings. I think, was it you, Holly, that said?
Yes, it was, the
Yeah.
fundraiser.
Yeah, they talked about fundraisers and all. These are all good ideas that could have been explored, but they were just jettisoned without consideration, you know?
Our board really has given us a very, very poor decision. It's either all or none.
Why can't we
And-
go with just one? Why
And,
can't
and
we
yeah,
go?
yeah, why can't we go with one? You know, why can't we meet halfway? So,
That's part of the problem, is that they took a very complex situation and they tried to funnel it into a single solution, and to the exclusion of all other potential solutions out there that merited consideration.
yeah.
And that's the problem. They were laser focused on what they felt was the right thing to do, and they wouldn't even consider any of these other options that people brought up.
It's not even the right thing to do. It's they focused on what they wanted to do.
Mm-hmm.
That's in my opinion.
Yeah, I assume they thought it was the right thing to do. I'm trying to give them the benefit of the doubt. But yeah, so. Yes, sir.
Does the president have the authority to close the golf courses, like he has threatened?
No,
He has
That's a good question. That's a great question.
If I don't have this money by October, I'm gonna close both the courses. Does he have this authority?
That's-
Does this board?
The board has the authority to stop funding the golf courses, and that may ultimately cause the golf courses to close. But the LLC controls the operation of
There's
the golf
three-
courses.
All three of them
Well,
are
they were
on
one
that
and the
board.
same.
Yeah,
Yeah.
so they could, yeah, but it's not an individual decision, it's a collective decision of the board. But you're right, it seems like the same three people that vote together are on both boards.
Can I follow up with that?
Yeah, sure.
Well, if they're both on the same boards,
Conflict of interest.
where are we? That's a conflict of interest, isn't it? They shouldn't be able to say, I'm gonna close this and come into a meeting for the HOA and say, I'm gonna close this.
And we want your money to fund our club. I don't get that.
Well, that's where I think there's real issues. When they start determining how much money to transfer, that's when I believe there's a huge conflict of interest. As for the question on closing,
Go ahead.
that, to me, there's a little bit more gray area, but I would say that like Jim has said, no single individual has that power to say, close the doors. It should be, since we're funding it, it should be all of our decisions. And the board should listen to us and ask us what we want to do. And so, if we get to that point, it's going to be a very, very interesting discussion.
Yes.
You know, on the vote, it says, do you vote yes for the amendment change? And then it says, do you vote yes or no for the 175 special assessment?
Right.
How would you, if there is no golf course, what's that special assessment for?
It's meaning,
Do you know what I'm saying? It just doesn't make sense.
Right. That's correct. That's why, I think that's why they've advocated that people cast their vote yes for both questions.
I wasn't here for
We're advocating that you cast your vote no.
And that would automatically be a no for the special assessment.
I couldn't understand why voting was supposed to start taking place on October 1st. But then that thing come out on what day was it, Thursday or Friday or whatever?
Yeah, like the 27th or 26th.
Yeah, we changed the date. We're gonna start it tomorrow or whatever they said.
Well, let me,
Go ahead.
that seems to be, how this board operates. It's very, very capricious how decisions seem to be made. If you go back a couple of open meetings, the president was talking about postponing till halfway through October. And so then to suddenly be October 1st, and then suddenly to be, okay, well, we're gonna open it the 27th,
Right.
who's in charge here? What's going on? So, I think that's a very valid complaint, that
These
there's
decisions
no
should be-
consistency.
Yeah, these decisions should be made pursuant to a vote taken in an open board meeting. And it's concerning that decisions are being made outside of open board meetings and they're being changed outside
Very
of open board
capricious.
meetings. Yes, sir.
Somebody that's lived here a lot longer than I said that they're supposed to send out a letter 2 weeks ahead of time
That's correct.
before it's voted on.
That's correct.
Well, I never got it.
We never No.
Yeah, there's-
Well, I understand that that's what they're supposed to do. You're supposed to get at least
Yeah,
14 or 15 days notice
yeah.
in advance of the vote.
We didn't get that. That's another thing.
Well, it may have gone out, but for all you know, it may have gone out Friday, you may get it tomorrow.
Well, it's in the mail. I can check.
But if there's a lead time before the voting opens, they certainly didn't make that requirement.
Yeah,
Yes.
2 weeks after the letter comes out, that's when you start voting. After the people receive it. That's the way I understand.
Well, it depends on whether you're voting electronically or, folks can elect to get notices electronically as well. So if they send out electronic notices on Friday to people that elected that, those folks are getting their 2 weeks notice.
Well, I
I don't know the facts, so I don't wanna comment further than that, but that's typically how.
I think there's a lot of issues. He being the president, said that he's going to do this right. And from what I can see, there's a lot of errors being made. And, if he starts complaining about people complaining, well, sorry, but this is the environment you've given us. So to me, it seems very chaotic.
Are there any other questions? I thought there was a hand back here, maybe, concerning the lawsuit. But if you have questions regarding the vote, that's fine too. Happy to take those.
And to your question, what are we going to do if we're going to win? I've had a bottle of champagne in my ice box for the last 3 years. I'm finally going to have an opportunity to open it.
Yeah, we're coming.
Okay. It's not that big of a bottle, but we
So if
can
this
go drink
passes
it.
and y'all win, what happens?
Say again, please.
Let's say
They won't pass.
the vote passes.
Right.
They get their 14 and 11 because no one reads, obviously. So
The lawsuit continues.
the lawsuit continues. Y'all win. Let's say y'all win.
Right. If we win all the counts of the lawsuit, then it would be unwound. Everything would be unwound.
All right.
Including the addendum.
How long
Well,
is,
I'm talking about the addendum that relates to the changes to the golf course, yeah, which would be everything on the addendum.
how long does it typically take for something like this to be on the docket? Don't tell me years, we might not be live by the time.
We're gonna try and accelerate it as much as we possibly can. That's why when we served our complaint, we served also with it initial discovery. We served requests for production of documents, requests for admissions, a first set of interrogatories. So, once we get responses to that, I'm gonna start taking depositions and then notice it for trial. I hope to notice some of it for a motion for summary judgment, so we can get issues decided even before trial.
Are you hoping by the end of the year at least, or?
The end of this year?
Yeah,
No way,
that's what I figured.
no. Unfortunately, the law moves slowly, but,
And it's a complex case, I mean,
Yeah,
it's fairly,
it's a fairly complex case. It's not rocket science, but it's a
it's
case that,
involved.
it's a case that, it's a 51-page complaint plus probably another 200 pages of documents attached to it, so the judge is gonna need to take some time to sift through it. It took me, weeks to sift through all the documents that I sifted through in order to compile and summarize and condense into those 250 pages where I thought to be the strongest argument. So, yeah, it's a complex case, and it's gonna take the judge some time to get his arms around it.
And it's the judge, he makes the decision, period,
Well,
right?
We've asked for a jury too. If it
You've
goes to
asked for a jury,
If it goes to
okay.
a trial, but the judge is gonna be making all the principal decisions early on in the case, yeah. We've got a good judge,
Good.
assigned to the case, so I'm happy with the assignment.
But I'm looking forward to the depositions. I'm
There are gonna be
looking
a lot
forward
of
to getting
There's
some
gonna be a lot of
answers.
depositions to take, yeah.
There are a lot or not?
There will be a lot of depositions to take.
So are y'all deposing like Lee and all the, I don't even know if you can tell me that. All
Well, we can, yeah.
the past
it's-
managers and stuff like that and past boards?
We're gonna have to talk about it, because obviously there's a cost to depositions. Depositions are expensive, and Ed's a generous man, but I'm sure his pocketbook's not limitless. So, and Janet too, so, I'm sure we're gonna, Have a budget?
If you see me out in the corner with a
I'll
can,
drop a can, I'll drop it in
for
there.
depositions, I'll have a sign for it.
but I can tell you, we will take the deposition for sure of Mr. Roberson, Mr. Alpert. We're gonna talk to Leonardo and Company, the auditors, as to why they failed the audit.
Past president.
We'll probably talk to the past president. Yeah.
Right.
We're gonna be judicious in who we depose, because they are expensive and time-consuming processes, but, yeah, we're not gonna spare expense if it's necessary to invest the expense. At the same time, we're not gonna go wild and depose anybody that we can depose that may have some knowledge. We're gonna have to be surgical.
There's gonna be two votes. One is for changing the documents and one is for the special assessment.
That's correct.
So you could win one and lose the other.
Well,
Maybe
that's
get-
you guys are voting on that. So, if we win the lawsuit, it would essentially serve to unwind all of it.
Because if they win this, the special assessment vote, they'll have I guess, some kind of time frame when it's supposed to be paid, and the lawsuit may not have happened yet at that point.
May not have been concluded at that point in time, yeah.
Am I correct in saying that the president said if that did not pass, the amendment or the documentation, that they would close?
Yeah, I heard that.
He was going to close them.
Yeah, that's what I heard too.
So
The
either
next
way,
day,
whether you vote yes or no, you're gonna get, he's gonna wanna close
the
them.
next day.
And what,
Well, you're saying if we prevail in the lawsuit, he will close it.
No,
no,
he
if
made
the
a
amendment passes,
Oh,
If it doesn't.
yeah, then
does
he's
not.
getting everybody's commitment to $175. I think Kathy said that. For what?
Mhm.
For what if there's no golf courses?
Yeah, yeah. Well,
He's closing them down.
Again,
Oh, I see what you're, so if he gets a no
He
and a
made the
yes.
threat that
Yes.
he would close them down.
Yeah.
It was that simple,
The next day.
yes.
and again, that's the brinksmanship of this particular board, right? They push it to the edge,
Mhm.
to get people apprehensive and force them maybe to make the decisions that not as well thought through and well researched as it should be.
If I can interrupt, Jim.
Go ahead.
Our cameraman has been giving me the high sign, so I believe
Okay.
we're kind of on the short end of this.
On the, my wife is signed up for the blasts that come out to the residents. Somehow she's got my name tagged to it. But anyway, in there, it gives the meeting agenda for
What, the
October 29th at 3 o'clock.
Right.
But anyway, in that agenda, item 4, number 2, says proposal, vote and results of special assessment of $175 per lot, due November 15th, 2024. Quotation, or parentheses, note, both of these items will be considered at the same time.
Okay.
So, does that kind of mean like, when we determined, you could say, well, this fails on the amendment, this passes, but we're gonna shut them down. I don't care which way it goes.
Yeah. You can,
That determination
Yeah.
the
will
board,
be
the
that.
board can do that, the LLC,
Right.
the board can do that, yeah.
So we'll know more.
But they would have to do that again in an open board meeting.
Right.
One person can't make that decision.
Right. Okay. But that's the status on that.
That's the agenda. So, it's interesting, he hasn't, scheduled any, open meetings between now and the 29th, is that the first meeting?
I think so.
As far as I
Yeah,
know.
that's interesting, you know?
Well, I think that,
Yeah.
personally, I think that he's trying to reserve as much of that time as possible to continue to reach out to people and talk them into
Yeah.
sending in a yes vote. I think he's been working the phones, I think he's been working the emails. I think he takes this very personally, that's obvious.
Yes.
He takes it very personally. It's like his,
Yeah, I heard about snowbirds, yeah.
Yeah, he's got people calling in.
And see, I don't think they really know.
Probably not, yeah, probably not.
That's the worst part of it, they probably don't know what's going on. And I don't know what the ratio is, the people that actually live here and people that
Yeah. Yeah, well, maybe we should man the phones as well. Anyway, well, why don't we wind it up? It's been a pretty good afternoon. So, again, thanks everybody for showing up. Thank you for your questions.
thanks for the question.
I'd like to thank Janet Eisenhower for allowing us to use her home. And,
Thank you guys.
of course, to Jim Costino for all the service he's
For
provided
your time.
now and in the future. Thank you.